Patent Wars. This presentation explains who's in battle, how the warfare is conducted, and how infringement lawsuits in the US are affecting the global trade in patents. Traditionally, patent litigation battles were conducted by product companies against their competitors, other companies selling competing products. As an example, Polaroid sued Kodak for infringement of its instant photography patents when Kodak released products using the Polaroid inventions. Polaroid won this case, by the way, and Kodak was forced to shell out almost $1 billion in royalties. Counterclaims of infringement are common in these types of lawsuits. Upon receiving claims of infringement from Polaroid, Kodak could counterclaim that Polaroid was infringing Kodak patents. Counterclaims are an effective deterrent to bringing this type of competitor versus competitor litigation. Many infringement cases today are brought by patent licensing firms, essentially firms of lawyers rather than product marketers. As an example, a firm called NTP owned a patent covering the transmission of email messages to mobile handsets. NTP did not manufacture or market this technology, or any technology. NTP's entire business was focused on asserting patents. RIM, the manufacturer of the BlackBerry handset, was found to infringe NTP's patent and forced to pay NTP around $600 million in damages. There was no point in RIM bringing a counterclaim of infringement against NTP. As NTP did not manufacture or sell any products, it was essentially immune from such defensive action. Interestingly, this case threatened to shut down the entire BlackBerry service. Injunctions preventing future infringement were routinely issued by the courts, as well as damages in the form of royalties for past infringements. If RIM had refused to settle with NTP, the court would have issued an injunction that would have shut down the BlackBerry service. This would have meant an email blackout for the BlackBerry handsets on which many US businesses and organizations rely, including the US Supreme Court. As we shall see in the next case, this triggered action from the Supreme Court justices. eBay was found to infringe a patent on an invention covering the use of credit cards to pay for goods acquired in an online auction. The patent was not held by a competitor, but by another specialist litigation firm that sole purpose was to assert patents. A finding of infringement threatened to shut down the entire eBay service if the court had issued an injunction to prevent future infractions. The US Supreme Court decided here that injunctions were no longer automatically issued following a finding of infringement. The court looks at several factors to determine whether the injunction is necessary or in the public's interest. Following this eBay case, injunctions no longer issue to patent holders that are not competing in the market. If the plaintiff bringing the suit is not an operating company actively making and selling products in the marketplace, the best it can hope to win from an infringement suit is a reasonable royalty. The courts no longer award injunctions in these cases. However, if the patent holder bringing the suit is a competitor whose future business will be damaged by ongoing infringement, the court will award an injunction, so long as it's not too harmful to the public. So, the nature of the patent wars is constantly evolving. The growth in lawsuits by professional litigators has been stemmed in recent years, and more changes are expected as a result of the ongoing reviews of the federal patent and litigation laws. In the patent wars, lawsuits are brought by a variety of organizations, including operating companies and specialist firms of patent enforcers. On the other side of the battle line, there's essentially only one type of defendant. The accused infringers are almost always large corporations with very deep pockets that are actively marketing products in the United States. A skim of recent patent cases show these large corporations repeatedly finding themselves the targets of such patent lawsuits. As a response to repeated attacks, large corporations have adopted a number of defensive strategies. They're forced to invest in building up their patent portfolios and their legal teams. Building the patent portfolio can be achieved by acquiring existing patents from other patent holders and filing new patent applications. When acquiring patents from others, the company is removing potentially damaging weapons from the marketplace, as well as strengthening the company's own position. Pooling patents and cross-licensing with other corporations makes sense in many industries, as this provides rapid and cost-effective access to large portfolios. When dealing with patents, corporations take steps to operate in stealth mode. They try not to disclose their weaknesses and work through intermediaries in order to stay under the radar and out of the sight of the patent enforcers. In the patent wars, the battle lines are drawn. Litigation-oriented patent enforcers on one side and wealthy product-oriented corporations on the other. Patents are the arms fueling the wars, and they are actively traded on the market today. Patents with evidence of infringement are the most dangerous and the most valuable. By restricting the issuing of injunctions, the U.S. Supreme Court recently weakened the strength of the dedicated patent enforcers. New bills are before Congress and new cases are scheduled to be heard by the Supreme Court. The nature of combat may change, but this war will continue for many years to come.